this week's class. So this week we will be discussing chapter 4. So we're going to go ahead and start on chapter 4, page 1. And we're going to be on the 4th paragraph where it tells you the types of questions that an employer may include in a job application or ask during an interview are limited. In general, an employer may not ask an applicant questions regarding the following bullet points. Now keep in mind, this is pre-employment. This is before you know you're going to give this person a job. So for example, if that person were to fill out an application, come to an interview, one of the questions that you would not want to ask is how old they are. Now you can ask, are you at least 18 years old? But you cannot ask them directly how old they are. Now when it comes to national origin, nationality, sex, sexual orientation, or marital status, all that stuff is personal information, not really needed to know if you're going to give that person a job, right? So marital status, you don't have to know whether someone's married to give that person a job. National origin, you don't have to know where they're from to give that person a job. That stuff is personal information. Again, not needed to know to give that person a job. Especially religion or lack of religion. That's personal issues. Those are personal things you don't want to ask during an interview, because if you ask any of that directly, where they're from, if they're married, what religion they follow, and you ask them and they give a wrong answer or something that they believe was a wrong answer, you're opening the door to a lawsuit. And these are things that are avoidable. So you can't ask these questions. You cannot ask these questions in the application or during an interview. In regards to the arrest record, you can ask someone if they have a misdemeanor or a felony on the record. So that's a question that you can ask. Have you ever been convicted of a misdemeanor or felony? If they say no, that's where the conversation ends. If they say, yes, I was convicted of a DUI in 2 years ago, then you can ask more details regarding that case, but keep the question very, very simple. Have you ever been convicted of a misdemeanor or felony? Now, medical history or disabilities. During the pre-employment application or during the interview, you want to sway away from this. If they're disabled in any way, you're probably going to find that out during the physical that's needed to give them the job, but sway away from these bullet points. You want to keep applications and interviews really focused on that person's experience. If you're a roofer, for example, and you're trying to hire a roofer, keep the application really based on the experience from previous roofing companies that they're working on, or throw in some questions during the interview regarding specific questions regarding that trade. You don't want to make the interview more based on personality or personal questions. Make your interview based on the experience. That's what you really want to focus on, the experience that employee has. When it comes to getting that person's personal information, such as their social security number, their ID, for example, once you give them the job, that's when you can ask for their ID. You can see how old they are. You can see their personal information along with their social security number. Once you decided to hire that employee, not before. This is pre-employment application, pre-employment interview. You don't have to know any of this stuff to give someone that job. Now, in the last paragraph on page 1, it's letting you guys know an employer may not fire or refuse to hire a person because of race, religious creed, color, nationality, ancestry, physical disability, mental disability, medical condition, genetic information, marital status, sex, gender identity, gender expression. Basically what this is telling you, you cannot fire someone because you're discriminating against them. You cannot fire someone because of any of these reasons. Now, under the last bullet point on page 1, let's go ahead and read that. In some instances, you may require the applicant to perform a skills test to demonstrate that they have the necessary knowledge and skills to perform the job. That's exactly what I'm talking about. So if you're hiring a plumber, create a 10, 20 question exam for them just to kind of see where their general knowledge is. And then, of course, Normal standard probationary periods are 90 days. So let's say you do hire that person and that person doesn't meet the skills requirement and you notice that within the first week, 2 weeks, 3 weeks, feel free to dismiss them. Because again, standard probationary periods is 90 days. So they're on probation for 90 days. So if you feel like they're not meeting the adequate skills necessary to perform the job, you're still allowed to dismiss that employee. Okay, let's go ahead and chapter 4, page 2. Chapter 4, page 2. The very first bullet point, it tells you, you may choose not to hire employees if they are under 18 years old. In many cases, it would be illegal to hire a minor. For example, Labor Code Section 1294 prohibits persons under 16 years old from working in scaffolding. In construction, I wouldn't hire anyone under the age of 18. In construction, any type of trade, I would not hire anyone under the age of 16. Under the age of 18. My personal recommendation, sway away from that. Make sure they're at least 18 years old if you're planning on hiring them for that specific construction trade. Now, in the second bullet point, it tells you an employer may refuse to hire applicants whose medical condition or disability will prevent them from performing the major functions of the job or from performing the job in a way that will not endanger the health and safety of the applicants or other workers. So this is exactly what I'm talking about. If that person has a medical disability that will either hurt them or hurt other employees, you can actually refuse to hire them by law. So for example, if this person has a disability where they can, let's say for example, they can faint at any moment. They can faint in any moment. Imagine them being on the top of a house or a building, on a roof. On a roof, you have to have your balance because you can fall from that roof at any point. So if this person has a disability where they can faint at any moment, obviously you cannot hire that person. Now, this is normally known when you're performing a physical, and they actually have to declare that in that medical form. Or normally, hopefully that employee will let you know regarding, hey, I might have something that can prevent me from working here. Maybe find them a job that they can do, or again, refuse to hire them if they're going to put themselves at risk or other employees at risk. So yes, medical conditions that can prevent them from doing that particular job, or that can really endanger them or endanger other employees, you as the employer have the right to deny them that employment. The next bullet point, an employer may fire employees who cannot or will not provide documentation of their legal right to work in the United States. So yes, every single employee has to demonstrate that they're a citizen of the United States. They have to give either their ID and their social security card, and that's going to validate that they can work in the United States legally. But we're going to talk a little bit more about this in the following paragraphs. Now, where it says polygraph test, photographs, and physicals. Private employers may not require a job applicant or an employee to take a polygraph lie detector test as a condition of employment or continued employment. Federal, state, city, and county agencies are exempt from this law. So every single one of us is a private employer, which means that we're not a company in regards to a city company, a state company, or a federal company. We are private employers. Every single one of us are private employers. We cannot ask or force employees to take a lie detector test. Even if we believe that that employee is stealing money, stealing tools, we can never ask or force an employee to take a lie detector test. Only government agencies can. So for example, normally police officers, they are required to take a lie detector test as a condition of employment. Police officers are normally from the city or state. Obviously, we're private employers, so we can never ask or force employees to take lie detector tests, no matter the circumstances. In the second paragraph, it's telling you, some employers may require photographs of employees, usually for identification purposes. So yes, any IDs required to be on the project or required as a condition for employment, the employer must pay for it. And in the third paragraph, if you require physicals for your employees, just know that you need to pay the physicals. So if you're going to require physicals from all your employees, you as the employer has to pay for it. Keep in mind, this is tax deductible. So if you are requiring physicals from your employees just to make sure that they're healthy enough to perform the job duties, perfect. That is a tax deductible. Not only that, it will help prevent you from hiring anybody that is not physically healthy to do that job. Now, in the last two paragraphs on page 2, we're talking about the Form I-9. Form I-9 is used to verify the identity and employment authorization of individuals hired for the employment in the United States. An example of the I-9 form is on page 3. In the last paragraph on page 2 is letting you know, employees must complete the I-9 form their first day of employment. The employer must complete the I-9 form within 3 days. So again, on page 3, this is an example of the I-9 form. New employees have to complete this form their first day of employment. Section 2 of the I-9 form must be completed by the employer within 3 days. So if you keep reading where it says within 3 days of starting to work for pay, employees must present documentation to the employer that establishes their identity and employment authorization. So again, an example of the I-9 form is on page 3. Moving forward to page 5, to keep discussing the I-9 form, you definitely want to highlight that very first sentence on page 5 where it says, employers must complete section 2 within 3 business days of the employee's first day of employment. So the two things that I want you to know regarding the I-9 form is that the employees must complete this form their first day of employment. The employers must complete it within 3 days. Moving forward to page 6. So now we're going to be on chapter 4, page 6. Now, on page 6, you're going to see personnel files, or how I like to say it, personal files, right? These are the personal files regarding each employee. Some example of the personnel files are the bullet points there. Form W-4, the I-9 form, their job description, their attendance records, performance appraisal, and reviews. So these are not only are there personnel files, basically employee files, but they're also personal files, right? These are personal to every single employee. Now, there's a couple things that I want you to know. The first paragraph under the last bullet point, let's go ahead and highlight it where it says, personnel records should generally be kept for the entire time someone is an employee of the company and for a minimum of 3 years after he or she is terminated. And then in the next paragraph, this is what I really want you guys to keep in mind. This is the stuff that I seen when I took the state exam. You can either say personnel files or personal files can be viewed by the employee whenever they want or whenever they request to view them. So yes, an employee has access or should have access to view their personal files whenever they request to view them. I would always say at a convenient time for both of you, either before work, after work, or during their lunch period. Basically, your responsibility as the employer is giving them access to view their files. You cannot hide their files. You cannot never show them their files. That is their personal information. They need to have access to them. So let's say they've asked you multiple times and you're not giving them access to their files. Let's say they give you a written request to view their personal files. Now you have a deadline. Now you have to show them their personnel files within 30 days. So if an employee gives you a written request to view their files, now you have a deadline. You must make them available within 30 days. You also want to make sure you keep these personnel files in a locked room or cabinet. Keep in mind, these files have personal information on them, such as social security numbers, their address, how much money they get paid. That information must be kept in a locked room or cabinet. Why would an employee want to see their personal files? Let's say, for example, that employee wants to take out a loan or buy a house or anything really that requires their paycheck stubs, their W-2s, 1099s maybe. If they request these files from you, make them available at your earliest convenience. Now, let's go ahead and move forward to page 7, where it says employee handbooks. In the very first paragraph, I do want you to highlight that very first sentence where it tells you, an employee handbook provides information on employment policies. Above all else, that's what the handbook is for. Company policies or company rules. Now, they are going to give you some examples of the policies. So, for example, company policies, anti-discrimination policies, general employment, compensation, working hours, employee benefits, leave policies, safety and security. Basically, any information a new employee should know about the company should be found in the employee handbook. Workers' compensation information should be found in there. Safety procedures should be found in there. The injury and illness prevention program should be found in there. If an employee wants to know whether or not your company offers vacation hours, that information should be on there. If the employee wants to know how often they get paid, that information should be on there. Numbers to management, that information should be on there. Again, above all else, company policies, when you really determine the definition of what company policies are, company rules. How many sick hours does your company offer? Does your company offer paid vacation? That information should be found in the handbook. Or else they're going to be calling you every 5 minutes when they think about a question, right? It is your responsibility as an employer to have a handbook. Now, to make it even easier for you guys, most payroll companies help do this for you. So when you hire a payroll company to run your payroll, they will help you do this. Most of them do it free of cost. Now, in that first paragraph under the last bullet point, you want to highlight that paragraph in full where it tells you should have each employee sign an acknowledgement form when they receive a copy of the handbook. Keep one signed copy with the employee's personal file and give one copy to the employee. This is extremely important. As employers, you're not going to have a great relationship with all of your employees. This is a given. This is just going to happen. Someone eventually will dislike you. To help protect yourself and to protect your company, when you give a copy of the handbook, make sure they sign for it. Because let's say that employee gets injured in the future. What are they going to say? Oh, well, in this company, we never received safety training. We never do safety meetings. I never received the information regarding the workers' comp. They're going to find whatever excuse they can to sue you. So when you give a copy of the handbook to that particular employee, make sure that they sign for it. You're acknowledging I'm giving you the handbook. That way, if there is a problem in the future, you and your company are protected. Now, in the last 2 paragraphs on page 7, let's go ahead and highlight those paragraphs in full and let's go ahead and read them. Employee performance reviews can help employees improve performance and can help employers determine pay raises and employee bonuses. Consistent and honest performance reviews can also protect an employer from wrongful termination claims. You should have a performance review every 3 months. And the reason for this is because you can really set expectations with your employees. So if every 3 months you're doing a performance evaluation or a performance review, at least that employee can know, hey, I'm doing really good at my job. Hey, I'm doing really bad at my job. I need to change it. Not only that, if they have consistent good reviews, now you can validate giving them a raise. If they have consistent bad reviews, now you can validate firing that employee, suspending that employee, or cutting their hours. And in the last paragraph, it tells you, well before undergoing a performance review, preferably at the time of hiring, employees should be given a detailed job description. This will help them know what is expected of them in terms of job duties, and it will also provide a basis upon which management can do performance evaluation. When you are hiring an employee, you have to let them know what their responsibilities are. So if you are hiring a plumber, let them know what their job duties are. Are they doing the rough plumbing? Are they strictly doing maintenance? Let them know what the responsibilities are on the job site. Let them know what their job consists of. If an employee doesn't know what they should be doing every single day or what's expected of them, it's going to be hard to set that employee up for success. when you are hiring that employee, be clear with them and give them a detailed job description. Moving forward to page 8, chapter 4, page 8. The very first paragraph, I want you to highlight it, where it tells you, employees must provide information on the nature, illegality, and legal remedies that apply to sexual harassment. They may develop their own publications that meet government standards or use approved brochures and posters. Now, as employers, you will have a responsibility to help prevent sexual harassment in the workplace. Normally, all you have to do is give brochures, posters in the workplace. Normally, again, your payroll company will help you do that. Under where it says minors, it is a misdemeanor for an employer to hire or allow any person under the age of 16 years old to work in the following categories. Now, what I do want you to put next to this paragraph, go ahead and put, as 16 years old, you can be considered a hard laborer. At 16 years old, you can be considered a hard laborer, but you still cannot do these things on the bullet points. So 16 years old equals hard labor. On page 9, where it says paid sick leave. Now, this is in regards to how many sick days you have to offer each employee. In the second paragraph, highlight that very first sentence. Every single year, you have to offer 3 days of sick time to your employees. Every single year, you have to offer 3 days of sick time to your employees. 24 hours is equivalent to 3 days. 24 hours is equivalent to 3 days. Now, where it says strikes on page 9, go ahead and highlight that sentence where it tells you, a strike is a temporary stoppage of work by a group of workers, not necessarily union members, to express a grievance or enforce a demand. A strike is initiated by the workers of an establishment. People aren't going on strike because they're extremely happy with their job. People are going on strike because they feel they're not getting paid enough, you don't respect them, or they're working under dangerous work conditions. You always want to prevent a strike by treating your employees fairly, and by doing so, if you're doing those performance reviews every 3 months, you're setting proper expectations for those employees. Let's go ahead and move to page 10, chapter 4, page 10. I want you to highlight where it says the right to collective bargaining, unionizing. You're going to see that term in the state exam, the right to collective bargaining. So when you see that term, think back to this page. The National Labor Relations Act of 1935 established the rights of workers to organize into unions and negotiate contracts. An employer may not interfere with an employee's right to join a labor union. It is a misdemeanor for an employer to coerce or force any person to agree, orally or in writing, not to join or become a member of a labor organization as a condition of hiring. What I want you guys to know regarding this paragraph, next to where it says the National Labor Relations Act of 1935, go ahead and add this term, the Wagner Act. So what does the Wagner Act do? The Wagner Act protects the rights of employees if they want to join unions. So the Wagner Act protects those employees if they want to join unions to negotiate contracts with their employers. So let's say the employer retaliates, fires that employee, or cuts the hours of that employee. They are guilty of a misdemeanor and they can be sued in court. So just because an employee says, hey, we should join a union, I want to negotiate a contract with you guys, the employer cannot fire that employee, the employer cannot cut their hours, the employer cannot retaliate in any way. The reason why they can't do that is because there's a law that protects those employees. If the employer is found guilty of this, the employer actually has to rehire that employee. And if that employee was out of work for an entire month, 2 months, 3 months, the employer would have to go back and pay back wages. So they would have to pay them the entire time that employee was without work. Let's go to page 11, chapter 4, page 11. In the very first paragraph, I want you to highlight those 2 sentences. Now we're talking about time cards. Time cards are very easy to understand. Time cards are how we keep track of the days and hours that employee worked. So let's go ahead and discuss it. Employee time card should be completed daily. That's really important. A time card must be completed daily. A typical time card includes the employee's name, the pay period, a job or project number, the days and hours the employee worked, and a description of the work. So in a time card, there should never be personal information. You should never see how much money that employee makes. You should never see their address. You should never see their social security number or their ITIN number. Just the information found in the second sentence. The employee's name, a description of the work, days and hours worked. That's it. In the second paragraph, I do want you to highlight those two sentences. Time cards and other records on which wage computations are based, such as records of additions to or deductions from wages, should be kept for at least 2 years. However, payroll records must be kept for at least 3 years. So they're telling you that you have to keep time cards for 2 years, the actual punch the card kind of thing. But you have to keep W-2s, W-4s for at least 3 years. However, the IRS, which is a federal department, makes you keep those for 4 years. So state law is 3 years, IRS, which is federal, 4 years. Now we're going to go ahead and move on to page 12. Chapter 4, page 12. Now on page 12, there's so much information. Pay attention to page 12. We're also going to be adding a few notes. Now, on page 12, we're going to be discussing public works as well some information regarding wages. So let's go ahead and get to it. In the very first paragraph, make sure you highlight it. Highlight the entire page, but let's go ahead and read it. Wages must be paid twice a month on days designated in advance by the employer as regular pay days, either every 2 weeks or twice a month. Now, when you receive this question, when should you pay employees? When should you pay employees? It's not before work. It's not after the project. It's every 2 weeks or twice a month, okay? Sometimes they try to mix up the words a little bit to where it kind of confuses you. So if I tell you, when should you pay an employee? Look for the answer that equals to once every 2 weeks. So if you say every 2 weeks, that would be the correct answer. Once every 2 weeks, that would be the correct answer. Twice a month is the same thing. At least one time every 2 weeks. In the second paragraph, make sure you highlight this paragraph as well. If you were to fire an employee, you have to pay that employee immediately. You have to get their last check ready. Rule of thumb, if you know you're going to fire an employee on a specific day, make sure you have that check ready. Because if not, let's say that employee has to wait 1 day, 2 days, 3 days for their payment. Now you would have to pay them those additional days as well. If an employee quits without notice, wages must be paid within 72 hours. So if an employee quits without advising you, one day you get to work, the employee calls you, hey, I'm done here, I'm not coming in anymore. You have an additional 3 days to pay them. If an employee gives you at least 3 days notice, make sure they have their last check ready. So for example, if the employee tells you on Monday that their last day is Friday, you have to have their check ready on that Friday because they let you know that they were quitting on that day. In the following paragraph, again, make sure you highlight it. The employer may deduct for time lost if an employee is late to work. The deduction may not exceed the wages that would have been earned had the employee arrived on time. However, Labor Code Section 2928 allows the employer to deduct a half hour's wage for any time lost during the first 30 minutes of a workday. Now, if the employee is late 5, 10, 15, 20, 25 minutes late to work, by law, you can deduct up to 30 minutes in a day. This does tend to backfire on some employers because let's say the employee is 5 minutes late. They know you're going to deduct 30 minutes from their workday, so that means they're going to show up exactly 30 minutes late. You can choose to enforce this as you see fit, but this is a law. So you do have the opportunity to deduct a half hour's wage for any time lost during the first 30 minutes of a workday. In the following paragraph, make sure you highlight it as well. A wage deduction statement is a document that lists the deductions from an employee's wages, taxes, retirement contributions, etc. An employer must provide an employee with a wage deduction statement each time wages are paid or semi-monthly. The statement may be a detachable part of a paycheck or a separate itemized form if wages are paid in cash, which means, yes, by law, you can pay in cash, but you still have to provide them a wage deduction statement. A wage deduction statement is basically like a paycheck stub. So if you're paying them $1,000 in cash, make sure you give them a printed form where the form details what taxes you took out from the cash. I don't recommend paying in cash, always pay in a check. The last 3 paragraphs on page 12, last 3 paragraphs. I'm gonna try to make it easy for you guys, but I still want you to highlight it. Any contractor who bids on public works projects must first register with the Department of Industrial Relations. Make sure you guys know this. Department of Industrial Relations. You have to know the entire name and the abbreviation. DIR, Department of Industrial Relations. Additionally, the direct contractor and the subcontractors may not pay less than the specified prevailing wage rates, including overtime. So yes, if you guys are doing work, public work, you have to pay your employees prevailing wages. Prevailing wages are specified rates set by the city. So for example, if you guys get hired to paint Rialto High School, for example, right? Or any type of public school, publicly owned school, any type of public project, when you are submitting a bid for that public project, there are certain requirements that you have to read before submitting your bid, which means when they tell you, hey, there's a public opportunity, a public project open, they'll let you know, electricians on this project must be paid $30 an hour. Painters on this project must be paid $25 an hour. Plumbers on this project must be paid $50 an hour. This changes project to project, city to city. But employers are required to pay prevailing wages. Now, the director of the DIR sets the prevailing wages. So the director sets the prevailing wages for every project, city to city. Contractors must prove they are paying the prevailing wages by submitting certified payroll to the labor commissioner. So there's no way around this. If you are getting public projects, you have to pay prevailing wages. You have to prove you're paying prevailing wages by submitting certified payroll to the labor commissioner. Now, what else do we have to know? The public agency is required to post a copy of the rates at the job site so that the workers can compare their wages with the prevailing rates. So the department that's giving you this project has to have a poster, and on that poster is going to show all the prevailing rates. So if employees are getting underpaid, they're going to be allowed to see what they should be getting paid. A contractor or subcontractor who pays less than the rates posted may be fined up to $200 per day for each worker paid less than the prevailing wage, as well as required to pay back wages. Don't do this. A lot of companies get bankrupted when they go through a lawsuit because they weren't paying the prevailing wages. Basically, what they're going to tell you is you have to go back, pay the prevailing wages, the difference of every single check, and you're going to be fined $200 per day for each worker that you were not paying the prevailing wages to. Do it right from the beginning. Pay the prevailing wages to your workers. Public works of $1,000 or less are exempt from the prevailing wage requirement. So if the public project is $1,000 or less, you do not have to pay the prevailing wages. Now, I do want you guys to add a couple of these notes because this is in reference to prevailing wages and public projects. Contractors have 5 days to correct an error on a public works bid. So if you submitted a bid for a particular public works project, let's say you remember, hey, you know what? I didn't add the subcontractor's cost. I didn't add the materials getting delivered costs. I didn't add something, or you made a gruesome error on your bid, which could lead you to bankruptcy or the loss of thousands and thousands of dollars. You have 5 days to correct an error on your bid. After 5 days, the public agency can accept it, and you would have to do the work for the bid that you submitted. If your public works contracts is $25,000 or less, you do not need to register with the DIR. So if in your mind you know you're not going to be submitting bids over $25,000, And the majority of your projects are for reparations or the construction of additions or or any type of repair, let's say. You know that you're never going to submit bids over $25,000, then you would not have to register with the DIR. Contractors need both CGL, which is liability insurance, and workers' comp on public projects. So if you know you're going to be working on public projects, you need both insurances to qualify. You will need to have the liability insurance and you will need to have workers' comp. All right, moving on to page 13. I did go ahead and highlight that very first paragraph on page 13, but we already did discuss it. It's basically just telling you that if you're working on public works projects, you need to submit certified payroll to the labor commissioner, and that's to prove that you're paying the prevailing wages on those projects. All right, moving on to page 14. Now, under where it says wage garnishments, I do want you to highlight that first sentence where it tells you, wage garnishment is a legal procedure in which a person's earnings are required by court order to be withheld by an employer for the payment of debt, such as child support, consumer debts, or unpaid taxes. So this gets particularly scary when you have a solo ownership. So let's say you took out a loan. It could be credit card debt. Let's say you're $15,000 in debt. At that point, they can put an actual wage garnishment on your personal account or your company's account. Because remember, in a solo ownership, they don't separate you. You are the company and the company is you. So wage garnishment normally does occur when you owe child support, when you're in debt, or when you don't pay your taxes. They can put a lien on your bank account or a lien on the company's bank account if it's a solo owner. On page 15, if you owe child support, they can, so we're on page 15, amount number 1. Chapter 4, page 15, amount number 1, where it tells you 50% of the employee's disposable earnings if they are supporting a spouse or child. So let's say you had a child with someone else, you got remarried, and now you're supporting your current spouse or an additional child. They can still deduct up to 50% of your wages. 60% of employees' disposable earnings if they are not supporting a spouse or child. So let's say you were divorced, and now she put child support on you or vice versa. Now they can take away up to 60% of your earnings. If it's consumer debt, let's say credit card debt, for example, amount number 1, 25% of employees' disposable earnings for the week. So don't get in debt, protect your money. Solo ownerships are very, very at risk, especially for these wage garnishments. All right, guys, now we're going to move forward to page 17, chapter 4, page 17. So in that very first paragraph, I do want you to highlight it, and let's go ahead and read it. It tells you, an employer must comply with both federal and state employment tax laws. Federal tax laws are administered by the Internal Revenue Service, the IRS. The California Employment Development Department, EDD, handles the audit and collection of payroll taxes. EDD then routes payments and sends reports to the California Franchise Tax Board. So basically, if it's a federal tax law, it's administered by the IRS. Normally, if it's a state tax, it is administered by the EDD. Now, where it says W-2, I do want you to highlight that sentence. It tells you the W-2 is a form that lists an employee's personal information along with wages for the year and tax withholding. This is an example of the W-2 form. If you're on payroll, you should be receiving a W-2 at the end of the year. Moving forward to page 18, chapter 4, page 18. Go ahead and highlight that paragraph in full, where it tells you, employers with one or more employees must generate W-2 forms and file them every year. W-2s must be given to employees and submitted to the Social Security Administration by January 31st. You must also keep a file with your payroll tax records. The IRS requires all the tax records must be kept a minimum of 4 years. So when you are submitting a W-2 to your employee, you have to give it to them latest January 31st, obviously of the following year. So for example, we're in 2021. Your employee is going to work with you the entire year, and then you're going to give them their W-2 for 2021 latest January 31st. This is the same for a 1099. So let's say you hired a subcontractor or an independent contractor, you would have to give them a 1099 form latest January 31st. Now where it says W-4, where it says Form W-4 is a list of deductions claimed by the employee when determining the amount of FICA taxes withheld from each paycheck. In regards to a W-4, you're going to give them a W-4, give an employee a W-4 and an I-9 their first day of employment. So let's go ahead and make that note. Next to where it says W-4, you're going to give a new employee a W-4 and a I-9 form their first day of employment. We discussed the I-9 form at the beginning of this chapter, so make sure you go ahead and add that note. The W-4 is their list of deductions. If they're married, single, divorced, if they have kids, they have to update this information on their W-4. At the top of page 19, highlight the first sentence in the first paragraph, where it tells you, the employee's signed W-4 should be kept with the rest of the payroll records for a minimum of 4 years. So above all else, IRS, they make you keep your payroll, anything having to do with payroll, W-2s, 1099s, for at least 4 years. Remember, the IRS is a federal department. The Internal Revenue Service, or IRS, is a federal department. Now where it says independent contractor versus employee. Now this is where it kind of gets a little confusing. This is where you can say, well, that's not my employee. He's an independent contractor or subcontractor. As a general rule, a worker is regarded as an independent contractor if an employer has the right to control or direct only the result of the work and not the means and methods of accomplishing the result. If an employer has the right to control what will be done and how it will be done, the worker is an employee. So for example, if you're going to hire a painter for a remodeling job, you're a prime, you're a general contractor. You don't want to do the painting, you don't like doing the painting, you can hire an independent contractor. Now, of course, this independent contractor has to have the license. You can tell the painter, hey, I need you to paint the entire house, exterior and interior. Okay, awesome. Now we have a contract between us. My job as the painter is to paint the interior and the exterior. However, the general contractor cannot tell me how to do my job. I have my own methods of accomplishing that result. So basically, the general can tell them what to do, paint the interior and exterior of the property, but not how to do it. I know it's a little confusing, but this is the correct answer. This is the answer that you want to look for if they ask you what's the difference between an employee and an independent contractor. Under the last bullet point where it tells you, subcontractors are not usually employees of the prime contractor, but they have a contractual relationship in order to complete a specific task. That is correct. Prime contractors have a contract with a sub, and that's why I tell you guys, subcontractors also need to have a license. They have a contract between them. The prime tells the subcontractor, I need you to do this, but they can't tell them how to do it. Now, in regards to when is a subcontractor considered an employee as well, on public works. On public works, a subcontractor is considered an employee of the prime, but strictly on public works only. Strictly on public works is a subcontractor considered an employee of the prime, not on private works. Make sure you add that note. Repeat this section if you must. Subcontractors on public works are considered employees of the prime, but not on private works. Private works are residential and commercial. Now, in the last paragraph on page 19, you want to highlight that sentence in full as well, where it tells you, an employer who has one or more employees, whether temporary, part-time, or full-time, must obtain an employer identification number from the IRS. Remember, if you have a solo ownership, you don't have to apply for the EIN until you hire your first employee. Why? Because they don't separate you from the company. You are the company. So you can technically use your social or ITIN number to open the company. But once you hire your first employee as a solo owner, you need to apply for that EIN number. Okay, moving forward to Chapter 4, page 24. Now, I know we skipped a few pages, but it's going to make sense in a little bit. When studying taxes, I want you to study this page. When studying taxes, I want you to study this page. On the left-hand side, it tells you what taxes the employer pays. In the middle, it tells you what taxes both of them pay. And on the right-hand side, it tells you what taxes the employee pays. Now, I do want you guys to add these notes on page 24. SEIN. What is the SEIN? The SEIN is the State Employer Identification Number. This is used to deposit your payroll taxes. EDD. The EIN, the Employer Identification Number, is used to deposit your company taxes. IRS. FUTA. FUTA must be paid for the first $7,000 of an employee's wages. After that, you stop paying until the following year. FIT has no limit. FICA, 50% employer, 50% employee. They both pay FICA. Sales tax, otherwise known as use tax, is deposited to the State Board of Equalization. Deposits depend on the estimated money to be made. All other taxes are deposited quarterly. All of the taxes are deposited quarterly, which quarterly means 3 months. Okay? So again, when studying taxes, I definitely want you to study page 24. Now we're going to move forward to page 26, where it says workers' comp. In the third paragraph, I want you to highlight that sentence in full, where it tells you, under the workers' compensation law, an employer who is insured for workers' compensation may not, with certain exceptions, be sued for job-related injuries. So if you have workers' comp, you're following all the steps necessary. If an employee gets injured due to the work, accidents happen, right? You can't prevent an accident to happen, right? You can try to minimize it, but accidents, that's why the term is accident, right? If you have workers' comp, you took all the steps to prevent the accident. You took all the steps that is required of you as an employer. They cannot sue you just because they got into that accident. Now, if you don't have workers' comp, an employee gets injured, they can definitely sue you. Now, in the last paragraph on page 26, I do want you to highlight that sentence in full. If you are a C39 roofer, you are getting the roofing license. Even if you don't have employees, you need workers' comp. If you are a C39 roofer, even if you don't have employees, you need workers' comp. Now on page 27, number 1, go ahead and highlight it. It tells you, by purchasing a standard approved workers' compensation insurance policy from an insurance company or the state compensation insurance fund. This is telling you where you can purchase workers' comp. Workers' comp normally for new employers that just got the license, it is strictly from the state compensation insurance fund. You're normally not going to get approved through a private company your first few years. The majority of the time, the policies are issued from the state compensation insurance fund. Now, where it says premiums, the third paragraph, I do want you to highlight that first sentence. The final premium of a workers' compensation policy is calculated when the policy term is over and the employer's payroll records have been audited. I get this question all the time. How much is workers' comp for 1 employee? How much is workers' comp for 5 employees? How much is workers' comp for 10 employees? Workers' comp is not based on the amount of employees that you have. Workers' comp is based on the amount of your payroll. Now, I don't have the specific formula for every trade. Once you get your license and you qualify to obtain workers' comp, I can refer you to numerous different insurance companies that we have, that we've done work with in the past, and they can try to find you the best price. Now, in the last paragraph, on page 27, where it says job-related injury, I do want to explain this a little bit more in detail. Workers' comp will cover any job-related injury. This does not mean just accidents that occurred in the workplace. Job-related injury means you were injured because of the job that you do every day. So for example, If you're picking up 100 pounds a day for materials, repetitive motion over and over and over again for years, and then after a while your back starts to hurt, that is a job-related injury, right? It's the same thing for people that work in an office typing a computer all day. They might get arthritis in their wrists or in their hands. That's a job-related injury. They are injured because of the work that they do every day. Workers' comp will cover them. So if you guys get the question, when will workers' comp cover an employee? It's not just accidents that occur in the workplace. It's not just, when they slip and fall in the workplace. It's any job-related injury or work-related injury. That would be the correct answer. Okay, moving forward to page 28. So basically on page 28, they're just giving you examples of when workers' compensation will deny you coverage. But let's go ahead and focus on the first paragraph very quickly. First paragraph on page 28, I want you to highlight that last sentence where it tells you, a general partner of a partnership or a managing member of a limited liability company may choose to be excluded from coverage by signing a written waiver. Now, this is an important paragraph for all my people that work directly with family or have a partner in their business. Normally, our family dragged us out to the construction trades at a very young age, 16, 17, 18. And let's say now they want us to open up our own construction company. Let's say you're working every single day with someone. It can be a friend, a dad, a mom, a brother, uncle, cousin, whoever. You're going to be working side by side with this person every single day. Instead of doing a solo ownership and having to pay workers' comp for them, it would make 1,000 times more sense to open up a corporation, add them on as a partner to where you don't have to pay workers' comp for them, because you know you guys are going to be working at the job site day after day after day. Why risk getting a fine from the workers' comp company when you can simply add them on as a partner and not pay workers' comp for them? We help you with that paperwork here when you open a corporation with us. Going to page 29. I mean, you could read the bottom of page 28. It's pretty simple stuff. Just kind of tells you when you're not going to be covered by workers' comp. I mean, some of them are pretty obvious. You were drunk or intoxicated at the workplace. You get hurt. They're not going to cover you. The injury is self-inflicted. They have proof it was self-inflicted. They're not going to cover you. Unfortunately, if the employee commits suicide, they will not provide benefits to their family. Right? That just kind of helps prevent people killing themselves or committing suicide to give benefits to the family. In the bottom of page 28, it just tells you what it covers. It pretty much covers anything: medical benefits, vocational rehabilitation, permanent disability, death, and bureau benefits, if you qualify for it correctly. Now, page 29. Page 29 has a lot of things we need to highlight. Make sure you highlight it. Let's go ahead and cover it. In the very first paragraph, employers must post conspicuously in a location frequented by employees a notice stating the name of the employer's workers' comp insurance company, or if the employer is self-insured. If the employer has purchased workers' comp insurance, the notice must include the expiration date of the policy. Failure to keep this notice posted is a misdemeanor. So what is this telling you? It's telling you in a place that's frequented by employees, normally like a lunchroom, or let's say you don't have an office, let's say in their toolbox or in your truck, somewhere where employees go consistently, you have to have a poster that kind of lets them know, what is my workers' comp company? How can I contact the workers' comp company? You also have to make sure that on that poster, it includes the expiration date of your workers' comp policy. If you don't do this step, that is considered a misdemeanor. You can get fined, suspended, or revoked your license. The employer must give new employees, either at the time the employees are hired or by the end of their first pay period, written notice that they have the right to receive workers' compensation benefits if injured at any time while working for that employer. So the first day of employment, you are giving that new employee the information regarding your workers' comp policy and the benefits they can receive if they were injured on the job. The easiest and fastest way of doing this is give that employee your employee handbook. That information should be found in your employee handbook. You include that information in your handbook and you have nothing to worry about. Now, where it says penalties, guys, these penalties apply even if you don't have a license. Even if you don't have a license and you have employees, these penalties will apply to you. Any employer who does not self-insure or purchase a workers' compensation insurance policy is guilty of a misdemeanor punishable by a minimum fine of $10,000 and or 1 year in jail for the first offense, and a minimum fine of $50,000 and or 1 year in jail for a second or subsequent offense. So for my contractors that are unlicensed and licensed, if you have employees, you need to have workers' comp. Failure to obtain a policy the first time is a minimum fine of $10,000 and up to 1 year in jail. If they catch you working a second time with no workers' comp, a minimum fine of $50,000 and this time another year in jail. Guys, get workers' comp. If you have a license, you need workers' comp if you have employees. If you don't have a license and you have employees, you still need workers' comp. Please understand that. In the second paragraph, the registrar of contractors may suspend or revoke the license of a contractor for failure to self-insure or to purchase a workers' comp insurance policy. So not only can you get the fine, not only can you get the jail time, the CSLB, which is the registrar of contractors, can also suspend or revoke your license. In the third paragraph, make sure you highlight that as well. The director of the Department of Industrial Relations or the registrar of contractors may issue a stop order. The stop order basically means you cannot hire new employees and they can put a pause on your existing contracts, which means you cannot continue to work until you purchase a workers' comp policy. And in the last paragraph on page 29, the employer is responsible for paying workers' comp insurance premiums. It is a misdemeanor for an employer to deduct the premiums from the wages of employees, which basically means you are solely responsible for paying workers' comp. If an employer that you know is taking workers' comp from your paycheck, that is illegal and is misdemeanor. I know this happens to a lot of contractors because they are uninformed of what the law actually is. They cannot deduct workers' comp from your company check. That is illegal and is punishable by a misdemeanor. Okay, so now we're going to move on. Chapter 4, page 30. Chapter 4, page 30. Let's go ahead and highlight that very first sentence on page 30 in the first paragraph where it's telling you, when you purchase a workers' comp policy, you must notify the CSLB within 90 days. However, when you purchase a workers' comp policy, your insurance company does this step for you. In the second paragraph, go ahead and highlight this paragraph in full where it tells you, if an employee is injured on the job site or is feeling that they're coming up on an injury and injury is starting to progress in their body, they must notify you within 30 days in writing. However, the only reason why they don't have to give you a notice is if a supervisor, foreman, or the contractor with the license saw the accident occur. In the third paragraph, it's basically telling you the employer has 1 working day after receiving that form that employee is injured. They have 1 working day to respond with the information regarding the workers' comp benefits that employee can receive. So if I'm an employer, one of my employees gets injured, I receive a notice that they are injured. Now I, the employer, has 1 working day to respond with the information regarding my policy and the benefits that employee can receive. In the following paragraph, it's telling you, an employer who has purchased a workers' compensation insurance policy should file the Form 5020 with the insurance company. The insurer will open a claim file before sending the form to the DLSR. So if an employee gets injured, you must fill out the Form 5020 and send it to your workers' comp company. You have 5 days from learning about the injury to give that form to your workers' comp company. And in the last paragraph, it's telling you, cities and counties requiring the issuance of construction permits must also require the applicant sign a workers' compensation declaration to verify workers' compensation coverage or exemption from coverage, which basically means when you go to the city to take out a permit, they will give you page 31. Page 31, you are simply stating, I'm doing the project by myself, I don't need workers' comp, and you're declaring that. So if the city comes and all of a sudden they see 10 employees at the workplace, they're going to fine you immediately. Or you're going to say, I do have employees, I do have workers' comp, and they're going to require you to fill out the information regarding your workers' comp policy. All right, guys, now we're going to move forward to page 33. Chapter 4, page 33, we're going to be talking about Cal OSHA and DOSH. So in the very first paragraph, I went ahead and highlighted it. It says, in 1970, Congress passed the Federal Occupational Safety and Health Act and created FedOSHA, a program aimed at developing and enforcing health and safety regulations for various U.S. industries. And in the second paragraph, if you focus on the second sentence, it tells you, so in 1973, the California legislature passed the California Occupational Safety and Health Act. So basically in 1970, federally, they passed FedOSHA to enforce safety and health regulations across all the companies in the United States. 3 years later, California decided these regulations are not strict enough. So California created Cal OSHA, which is California-based only. Now remember, Cal OSHA, FedOSHA, and DOSH, they pass and enforce safety and health regulations. Every single company in the state of California has to follow the laws set by Cal OSHA and FedOSHA. Because again, FedOSHA is federally, but California itself, the state, they passed Cal OSHA as well, which if you're a company in the state of California, not only do you have to follow FedOSHA laws, you also have to follow Cal OSHA laws. Now let's start explaining the departments under Cal OSHA. Number one, the Occupational Safety and Health Standards Board. So this is the board. They're the ones that sit in a room. They're the ones that decide how can we make these safety and health regulations safer for these employees. So they're the ones that either adopt or create more safety and health regulations. Number two is DOSH. DOSH are the enforcers. DOSH are the inspectors. They go out, they make sure the companies are following Cal OSHA procedures. Number three is the appeals board. So if you receive a fine from Cal OSHA, you have 15 working days to appeal that fine. And of course, you're going to appeal it with the appeals board. Number four is the consultation service. I went ahead and highlighted it as well, but let's read it. The consultation service helps employers and workers solve safety and health problems. Without fear of citation or penalty, private employers and public agencies and their employees may obtain the consultation service free professional assistance in identifying workplace hazards and in developing or improving accident illness prevention programs. So normally when you see Cal OSHA or DOSH is on commercial projects, big commercial projects, or very, very big residential projects. Like let's say if they're constructing 30 houses in a row, like they created a new neighborhood, that's when Cal OSHA might be there. It's very rare that in a remodeling job, Cal OSHA shows up. The only reason at that point they would show up is if someone gave them a tip that someone got injured or they're doing things that are not following Cal OSHA laws. That's when Cal OSHA would show up. So Cal OSHA is more focused on those big violations, either big commercial violations or big residential violations. So don't expect to see them at an everyday remodel. However, that does not mean you don't follow their laws. You still have to follow their laws. I'm just informing you that for most of you, if you're doing like remodeling projects or small residential projects, well, I've never seen them before. That's totally understandable. But once you do start getting to those, let's say, bigger commercial projects, bigger residential projects, it will become more common to see Cal OSHA or DOSH inspectors. At that point, you want to make sure that you have the IIPP program in place, that your employees have all their safety equipment, because these fines are not cheap. These fines are very, very expensive. So the consultation service is a free service that voluntarily helps you follow safety and health regulations. So I know for a lot of us, just as contractors, there's so many things that we have to be worried about. So let's say we do get an opportunity at a big commercial project and we're not 100% sure that we're following all the laws set by Cal OSHA. We can call their consultation service. They will send an inspector free of charge. They will let you know what we have to fix, and again, without giving you a citation or a penalty. How does this differ from another inspector coming? Because let's say you're not worried about them, you start the project, 2 weeks later, 3 weeks later, an inspector randomly shows up. If an inspector randomly shows up and sees that you're not following the safety and health procedures, instead of trying to help you, well, obviously at that point, they're gonna give you a fine. This is a free service. They send an inspector out to you directly and they help you follow these safety regulations. Moving forward, chapter 4, page 34. Chapter 4, page 34, where it says contractor employer obligations. I want you to highlight those two sentences and all the bullet points. We won't go through all of them, but I do want to highlight a couple of them. So, who is the contractor employer? That would be you. That would be the contractor that has the license who also happens to be the employer, right? So these are your responsibilities. Number one, maintain a place of employment that is safe and healthful for workers. Keep a clean work environment. Number three, provide an effective written injury and illness prevention program that includes the training of workers on hazards and safe work practices. We're going to get to this program on the next page. Display the Cal OSHA notice, safety and health protections on the job. This, your payroll company gives you this for free. Again, this is just a poster that you have to put that shows or informs your employees what their rights are at the workplace. Register with DOSH if his or her business involves the use of asbestos or other carcinogens, cancer-causing substances. If we are removing asbestos or we're going to be dealing with asbestos or really dangerous chemicals, you have to register with DOSH. Those are one of the more expensive fines. Those are common things where employees can really get hurt or get sick by dealing with these chemicals. So you have to register with DOSH. You must register with DOSH. Going to page 35. Now chapter 4, page 35, where it says obtain a DOSH permit for. Now, there's other situations where you would have to obtain a DOSH permit. These are just some of them. Construction of trenches or excavations 5 feet or deeper. Construction or demolition of any building, structure, scaffolding, or false work more than 3 stories, 36 feet high. Construction elevators, all large and small tanks. These are just some examples. There's other examples. Again, Google Cal OSHA, Google DOSH permits, and they'll inform you a little bit more. Now, in regards to the injury and illness prevention program, again, as you can see, this entire page is highlighted, but we're just going to cover some of the notes, okay? So the IIPP is a written program that is put into practice every day at the job site. So I want you to keep in mind, this program is not just a written program in the handbook and that's it, you forget about it. No, this is a written program that is put into practice every single day at the job site. Now, another thing that I want you to add, you might not see it here, but I do want you to add it on this page, or if you check the notes, it will be on the notes. Employers are obligated to provide information regarding safety procedures to new employees their first day of employment. This is why I really push you guys to have the handbook and include all the information in that handbook, because there's so many steps and rules you guys have to follow. So what else do we have to give a new employee their first day of employment? Just to kind of refresh your memory, we have to give them the I-9 form, the W-4 form, we have to give them the information regarding workers' comp, and now we have to give them the information regarding safety procedures. Again, if you include the majority of that information in your handbook, you're going to limit any mistakes. And that's why I'll always push to have all this information in your handbook. Keep in mind, employers are legally and solely responsible for safety. Employers are legally and solely responsible for safety. So it is your responsibility to ensure that your employees are using the safety equipment that you provide them. And again, you do have to provide them the safety equipment. They're not supposed to be paying safety equipment out of their own pocket. You have to provide them that safety equipment, helmet, goggles, those the reflectors. You have to provide that. That will come from your money. Okay, now if they lose them or they're damaging these on purpose, yes, you can ask them to pay for one or replace the one that they personally damaged. But if it's just normal wear and tear from different projects, at that point you would have to repurchase those PPE or the personal safety equipment. Now, keep in mind, safety meetings, toolbox, or tailgate meetings, they're all the same things. They're safety meetings. They must occur at least once every 10 days. So safety meetings must occur at least once every 10 days. The easiest way to do this is have a safety meeting every week. If you have a safety meeting every week, you don't have to worry about is this within the 10 days, right? Because if you do it every week, once every 7 days, you're going to be covered no matter what. Now, the Code of Safe Practices shows employees how to use hazardous substances in emergency and normal situations. You have to adopt a Code of Safe Practices, how to use hazardous substances or chemicals in normal and emergency situations. Okay, so those are just some of the things I wanted to touch upon briefly. Keep in mind, study this entire page, study the notes as well. In the last paragraph on page 35, as you can see, the entire paragraph is highlighted. It tells you employers must have at least one trained person to provide first aid at the job site. This is critical. You have to have one person that has their first aid certification at the job site. Because let's say something happens, an employee gets hurt, and it comes out that there was an employee that had that first aid certification, they can use that to sue you in court. Again, this is just building the narrative that you're not providing the information regarding safety procedures or adequately training your employees. You have to have at least one employee that is trained in giving first aid. Larger jobs may require more than one trained person. The job site must also have at least one first aid kit in a weatherproof container. This is key. If you're going to buy a first aid kit, make sure it's weatherproof. That way you're not buying a bunch of them. If you're going to buy a first aid kit, make sure it's weatherproof. The contents of a first aid kit must be inspected regularly to ensure that the expended items are promptly replaced. The minimum first aid supplies must be determined by an employer authorized licensed physician, or the employer can furnish the first aid kit with supplies according to table 1512. So who must choose the items in the first aid kit? Very simple, a doctor, a licensed doctor. Now, in regards to buying a first aid kit, just make sure that you go to Costco or Rite Aid or Walgreens. Some of them have those pre-packaged first aid kits already, and they tell you that it's Cal OSHA approved or DOSH approved. You always want to make sure as well that you're buying that you're going to be overly prepared, not underprepared. The other thing, if there's an accident in the workplace, like someone cuts their hand, small cut, they're not going to bleed out. Literally putting a Band-Aid on there will cure it. At that point, you don't have to report it to DOSH. So if there's an accident in the workplace where first aid was the only thing that was needed, that accident would not have to be reported to DOSH. I want you to add that note here since we're talking about it, but I'm going to repeat it. If there's an accident in the workplace where the only thing that was necessary was first aid, the first aid kit, it does not need to be reported to DOSH. Does not. Moving forward to page 36, chapter 4, page 36. PPE should be very simple for you guys. I don't want to spend too much time on this page, but we're going to go through some of them. In what examples do you have to give PPE? The first example they're telling you, if there's a risk of head injuries, make sure that your employees have their hard hats. The second one, if there's a risk of eye injuries, make sure your employees have their goggles. The fourth one, if there's a risk of hearing damage, make sure that you're giving hearing protection. Basically right here, it's 85 decibels or greater. There is tools out there to measure the decibels in the area. Now, what I want you to know is hearing protectors are needed when it's 85 decibels or greater. Okay, so if you guys get a question, when do you have to provide hearing protection? Look for the answer that's closest to 85 without going under 85. So for example, if you get the question, when are hearing protection needed? Option A is 80, option B is 90, option C is 100, and option D is 110. The closest answer to 85 without going under would be 90. That would be the correct answer. And in the last bullet point, when do employees require the fluorescent reflectors? The reflectors are needed when you're working at night. Okay, so now we're going to move on to page 37. We already covered so much in this class. I didn't want to make it too long, but I wanted to give you guys a little bit more detail to see how you guys like this class as well. You know, my last class was very the keynotes. So I wanted to see how this one worked as far as providing a little bit more details. Now on page 37, the very first paragraph, it tells you an employer must report serious injury, illness, or work-related death immediately. So anything that's considered serious, it must be reported immediately to DOSH. An injury or illness is serious if it requires hospitalization for more than 24 hours. So let's say the accident occurs, you guys go to the hospital, that employee goes to the hospital, and they're going to be there longer than 24 hours. That would be considered serious, and you would have to report that to DOSH. A blasting accident must be reported within 24 hours of the event, even when no injuries occur. If there's an explosion in the workplace, you need to report that to DOSH. And in the last paragraph on page 37, is letting you guys know, if the accident occurs on a public highway or a public street, you don't have to report that to DOSH. So if an employee wanders out on the street and gets hit by a car, you would not need to report that to DOSH. Going to page 39. Now on page 39, the first 3 paragraphs are highlighted. However, I want you to look at the notes I provided in this email. The first 3 paragraphs are talking about a near-miss situation. So in regards to a near-miss situation, these are the things that have to occur. A written report by a supervisor or foreman. An investigation must occur, but you do not report it to DOSH. So what is a near-miss situation? A near-miss situation is an accident that almost occurred, but did not occur. It was avoided. So if the accident was avoided, you do not need to report it to DOSH. But those 3 things must occur. An investigation, a written report by a supervisor or foreman, do not report it to DOSH. Now where it says record keeping, I do want you to highlight that entire paragraph in full, where it tells you employers who have 11 or more employees must record each employee injury on Cal OSHA Form 300. So if you have 11 or more, every single time an employee gets injured, you have to record that on Cal OSHA Form 300. At the end of the year, you're going to transfer the data from Cal OSHA Form 300 to Form 300A. All written health and safety records must be kept for at least 5 years. Current and former employees and their representatives must be given access to Cal OSHA Form 300 upon request. So if a new employee wants to know information regarding your safety record, the contractor safety record, all they have to do is ask you to see these forms, and you must provide them. In the last paragraph on page 39, the second sentence is telling you, anytime you buy a hazardous substance, it must come included with a safety data sheet. So anytime you buy a hazardous substance, it must be included with the safety data sheet. Going to page 40, the first paragraph on page 40, we already discussed the Code of Safe Practices when we were discussing the IIPP, but I want you to highlight anyway because it kind of reiterates the same information. But in the last sentence, it tells you, employee medical and exposure records must be kept for at least 30 years. So if an employee comes in contact with a hazardous chemical without the adequate protection, you would have to keep those records for at least 30 years. Inform them to see a doctor as well. Now where it says asbestos, the second paragraph, go ahead and highlight that. Lung cancer is 5 times more common in people who have been exposed to asbestos. Asbestos-related disease may not show up for 15 to 40 years. Due to this, you have to keep the records for at least 30 years. A lot of you might have been exposed to asbestos without even knowing it, especially remodelers or painters, drywallers. If you're working in a property from 1978 or before, the owner has to inquire whether there's asbestos in the property or not. Most properties 1978 or before have a lot of asbestos within the property itself. And due to this, the owner has to inquire it, hire a company to remove the asbestos. You guys should not be removing asbestos without the proper attire. There's an entire suit that is placed over the contractor to protect them when they're removing asbestos. So if you're a remodeling guy, the property's from 1960, 1965, and you're going in there and you're dropping down walls and removing the popcorn ceiling, all that has asbestos, and those things are getting lodged in your lungs. So be very, very careful, guys. A remodeling job in a property from 1960, 65, 70 is potentially dangerous. Make sure that client hires a company to make sure there's no asbestos in that property, because none of that is worth your life. And some of you are probably thinking, wow, I've already done projects like that. Just be very careful moving forward. Now, contractors must register with DOSH if they are working with asbestos containing materials with 100 square feet or more of surface area. Asbestos is very, very serious, guys. There's a whole license classification with asbestos only. That is a license as well. It's the C22 license. The unlawful removal of asbestos is punishable by a minimum fine of $1,000 and the possible suspension or revocation of your license. And in the last paragraph, an employer, owner, or contractor must determine whether asbestos is present before work begins on a project. Again, this applies to any building constructed from 1978 or before. Going to page 41. All right, guys, so in the first paragraph, I do want you to highlight that first sentence is basically just telling you how do they dispose of asbestos. Anybody that removed asbestos for a living as an actual working under a licensed company, they know that asbestos is removed and then they put bags on top of it. Normally these bags are resistant to asbestos, and they bury it with 6 inches of asbestos resistant material. So when they do bury it, it's on top. They put the bags on top, 6 inches of asbestos resistant material. Now where it says complaints and inspections, and tells you an employee or their representatives who believes that the workplace or work practices are unsafe or unhealthy have the right to file a complaint with DOSH. DOSH must investigate a serious complaint within 3 days, a non-serious complaint within 14 days. In the last 2 paragraphs on page 41, it's explaining to you a DOSH inspector might be able to put a yellow tag on a piece of equipment or the area itself. Now remember, this is yellow tag, not yellow tape. Yellow tag is an order prohibiting use, which means you cannot use that piece of equipment or enter into the area of the project until the yellow tag is removed. Only a DOSH inspector can remove the yellow tag. Now, this is chapter 4, you guys. Chapter 4 is a long chapter, but it's one of the chapters that we have to read from the beginning to the very end. I gave you as many details as I could, but if you guys have any more questions, please feel free to reach out to your instructors, or you can email me directly as well. Thank you guys very much, and make sure you guys study up.